So the first step in our presentation is to understand what is the cybersecurity even in a legal context. So first thing to understand is that the legal landscape of cybersecurity encompasses a complex web of regulation and obligation aimed at protecting sensitive information and ensuring robust defenses against cyber threats. This landscape is influenced by technological advancement, the increasing sophistication of cyber attacks, and evolving legal frameworks globally. In the US, the cybersecurity legal framework comprises federal and state laws, each addressing different aspects of cyber protection and data privacy. Notably, the Health Insurance Probability and Accountability Act HIPAA protects patient health information, while the Gram Leach Bailey Act GLBA and the Payment Card Industry Data Security Standard PCI DSS govern the handling of financial data. Recent developments include the Security and Exchange Commission's legislation on cybersecurity disclosures and the executive order on improving the national cybersecurity aimed at modernizing defenses. Additionally, the Cybersecurity and Infrastructure Security Agency, CISA, benefits from significant funding and enhanced federal cybersecurity measures. In the European Union, the General Data Protection Regulation stands as a critical regulation setting strict guidelines for collection, storage, and processing of personal data. GDPR emphasizes transparency in data collection, breach responses protocol, and data retention limits. The UK's Data Protection Act of 2018 complements GDPR by regulating the handling of personal data with specific attention to security measures against unauthorized use and data breaches. Furthermore, the UK has updated its legal framework to address cybersecurity more broadly. The NIS regulations focus on the security of information systems, especially for operators of essential services and digital service providers, imposing requirements to manage risk and report incidents. Technological innovation also poses new challenges and opportunities in cybersecurity management. The advent of behavioral biometrics, for example, offers sophisticated means to limit unauthorized access through the analysis of user behavior patterns. Yet companies must remain vigilant, as the majority of cyber attacks exploit human errors such as phishing. Globally, the cybersecurity legal landscape is undergoing continuous development. The EU's NIS2 directive aims to elevate cybersecurity across various sectors, while the UK is revising the cybersecurity legal framework to broaden the scope of regulated entities and enhance incident reporting mechanism. To navigate this complex environment, organizations must adopt a multifaceted approach that includes technical, organizational, and legal strategies. Implementing up-to-date security measures, conducting regular audits, and providing employee training are essential steps. Additionally, understanding and complying with relevant regulations such as GDPR, NIS regulation, and sector-specific obligations are critical for business to protect against and respond to cybersecurity threats effectively. So let's go deeper into details of the definition of cybersecurity into the various legal texts. So in comparing cybersecurity definition across the US, UK, and EU, the EU offers a concise legal definition within the Cybersecurity Act, focusing on activities needed to protect network system and users from cyber threats. The US does not provide a unified definition in federal law, but has a comprehensive coverage across various aspects of cybersecurity within its US code, emphasizing practices and trade sharing. The UK lacks a single cybersecurity law, instead relying on multiple legislation, including the Computer Misuse Act of 1990 and the Data Protection Act of 2018, covering cybercrimes and obligations related to system protection and incident management. So let's see them much more into detail. So as we know, we have a definition of cybersecurity in the EU framework in Regulation 2018-881, which is called which is on the ENISA, so the European Agency for Cybersecurity, and Information and Communication Technology. Cybersecurity certification, and repealing the regulation number 526/2013 called the Cybersecurity Act. There is a definition in Article 2.1 and 2.8. In 2.1 is explaining that cybersecurity means the activities necessary to protect networks and information system, the users of such system, and other persons affected by the cyber threats. And at 2.8, cyber threats are defined as any potential circumstance, event, or action that could damage, disrupt, or otherwise adversely impact network and information system, the users of such system, and other persons. There is another definition, or there are there is another nuanced definition that is put in Article 32 of the GDPR, in which is stated the security of data processing, taking into account the state of the art, the cost of implementation, the nature, scope, context, and purpose of processing, as well as the risk of varying likelihood and severity for the rights and freedom of natural person. The controller and the processor shall implement appropriate technical and organizational measure to ensure a level of security appropriate to the risk, included inter alia as appropriate. And then there is a list of anonymization of data and so on that we're going to see deeper when we're going to talk about them. In the US law, we have 6 US code, section 650, in which is defined at definition number 6 the cybersecurity purpose. That means the term cybersecurity purpose means the purpose of protecting an information system or information that is stored on, processed by, or transitioning an information system from a cybersecurity threat or a security vulnerability. And we're going to see later how are they defined in the 3 different legislation. As we say, instead, the UK doesn't have a peculiar definition and doesn't have an appropriate law that defines them. So we're gonna go in the next deeper in defining cybersecurity threat. So we have seen how much the definition itself of cybersecurity is interconnected with the definition of cyber threats, and hence the interpretation and understanding of cyber threats is very important both in the US, the UK, and EU landscape, even more important than the definition of cybersecurity. So what is a cyber threat? So in the EU, the regulation 2019/881 defines cyber threat as any potential circumstance, event, or action that could damage, disrupt, or otherwise adversely impact network and information system, the user of such systems, and other person. Okay. While in the US law, so in the 6 US Code section 650, and in the 8th definition, cybersecurity threat is defined in general as meaning an action not protected by the First Amendment to the Constitution of the United States or through an information system that may result in an unauthorized effort to adversely impact security, availability, confidentiality, or integrity of an information system, or information that is stored on, processed by, or transiting an information system. And in part B of this definition, the exclusion is the fact that cybersecurity threat does not include any action that solely involves a violation of a consumer term of service or a consumer licensing agreement. Now, definition number 8 needs to be interpreted in section 650 of the 6th US Code, by the 5th definition, that is the cybersecurity threat indicator, that gives us even more detail on what are the indicators of a cyber threat. So A cyber threat indicator means information that is necessary to describe or identify malicious reconnaissance, including anomalous patterns of communication that appear to be transmitted for the purpose of gathering technical information related to a cybersecurity threat or a security vulnerability, or a method of defending a security control or exploitation of a security vulnerability. See a security vulnerability including anomalous activity that appears to indicate the existence of a security vulnerability. Or D, a method of causing a user with legitimate access to an information system or information that is stored on, processed by, or transiting an information system to unwittingly enable the defeat of a security control or exploitation of a security vulnerability. Or a malicious cyber command and control, or the actual or potential harm caused by an incident, including a description of the information exfiltrated as a result of a particular cybersecurity threat. G, any other attribute of cybersecurity threat if disclosure of such attribute is not otherwise prohibited by law, or any combination of these characters. So we see how much in the US law there is even a deeper connotation of how a cyber threat needs to act and react, and it's important to, in order to evaluate the cybersecurity threat in itself, to take that into consideration. Finally, we have the UK laws, which do not define cyber threats, but actually define cyber crimes. So we could find that cybercrime is an umbrella term that is used to describe in the UK two closely linked but distinct range of criminal activity. The government's national cybersecurity strategy defined these as cyber-dependent crimes, crimes that can be committed only through the use of information and communication technology (ICT) devices, where the devices are both the tool for committing the crime and the target of the crime. For example, developing and propagating malware for financial gain, hacking to steal, damage, distort, or destroy data, and or network or activity. And on the other side, cyber-enabled crimes, traditional crimes which can be increased in scale or reached by the use of computers, computer networks, or other form of ICT, such as cyber-enabled fraud and data theft. So we talk about the legal breaches on cybersecurity, and how this legal breach could should actually trigger a response. But what is this response? And in this response, Cybersecurity Act. So we have to consider that the General Data Protection Regulation, the GDPR, represent a watershed in privacy legislation, mandating, as we have seen before in Article 32, stringent data protection and privacy for individuals. Within the EU and European Economic Area. The hefty fines levied on giants like British Airways and Marriott, and are testament to the regulation's reach and the seriousness with which breaches are treated. These penalties serve not just as punishments, but also as a deterrent, compelling companies to prioritize data protection or face severe financial and reputational consequences. So we see that cybersecurity becomes necessary as there are fines to be imposed, hefty fines to be imposed by under the GDPR standards towards the one that do not follow the guidelines in Article 32 of the GDPR itself. In the US, instead, the Federal Trade Commission, the FTC, is at the forefront of enforcing data protection laws through action against companies like Cafe Press, and for vulnerabilities like those found in Log4j. The FTC underscores the critical need for maintaining high security standards and swiftly remediating identified vulnerabilities. This approach not only protects consumer rights, but also reinforces the importance of proactive security practices in the corporate sectors. Then, beyond the governmental oversight, the security ecosystem is bolstered by private sector initiative and standards, guidelines from the National Institute of Standards and Technology, NIST, the Center for Internet Security, SIE's benchmark, PCI DSS for payment for payment security and oversight by bodies like FINRA represent a collective effort to elevate security practices across industries. These standards and frameworks offer blueprints for companies to secure their cooperation, emphasizing a community-driven approach to cybersecurity. Now, what are the legal paradigms which could trigger the sanctioning that we mentioned in the US and the GDPR? This would be related to negligence, and so the legal concept of negligence would apply when entities fail to meet a recognized standard of care and protecting sensitive information. And this liability framework assesses a company's security practices against industry norms, holding them accountable for lapses that led to data breaches. It encourages businesses to actively engage in best practices, aware that failing to do so could result in substantial legal repercussions. A second, instead, major important point would be the strict liability. And strict liability proposes a more stringent accountability model where entities are held responsible for security breaches regardless of fault. This paradigm aims to maximize security investment by ensuring companies are automatically liable for lapses. However, it also raises debates about fairness and the practicality of expecting businesses to guard against every conceivable threat. So, we have seen that there are two main things: strict liabilities and negligence that could be tackled and could be used as an excuse to be fined by the governments in the US and the EU. But what will these governments and the private business standards require to be compliant, basically? So we're going to see that, but now generally we could talk about the CIA triad, that is confidentiality, integrity, and availability. The CIA triad remains the cornerstone of information security, encompassing the principle of confidentiality, protecting information from unauthorized access, integrity, ensuring the accuracy and completeness of data, and availability, ensuring that authorized users have reliable access to information and resources. These principles guide the development of security policies and controls. There could be then additional pillars of secure system, which expand the CIA triad, which could be concepts like resilience, so the ability to recover from attacks, no repudiation, preventing denial of action, authenticity, verifying the source of information, and access control, so ensuring only authorized access. And those will be critical in addressing the evolving landscape of the security threats. These pillars underscore the multifaceted approach needed to protect digital assets comprehensively. There are then, hence, trade-offs in terms of security. What does it mean? That, as we say, because we don't want it to be fined through the idea of negligence or strict liability from governments, and we will need to have a cybersecurity framework based on CIA or the other pillars. But this doesn't come without cost, so there's going to be trade-off. And this trade-off will be the quest for absolute security is a mirage in a landscape of ever-evolving threats. Organizations must navigate the delicate balance between implementing effective security measures and managing the associated costs, including financial outlay, system performance, and user convenience. This balancing act requires strategic decision-making to ensure optimal protection without undue burden. And how do we find such balance? Through security heuristics. So, securities heuristics like the principles of least privilege, default score, configuration, or defense in depth, layer defenses, need to know accesses, open design, transparency, and adherence to standard solution, and treating security as a continuous process from the tactical playbook for defending against threats. These heuristics guide the implementation of practical, effective security measures tailored to organizational need. There is even an ethical side of cybersecurity. The ethical dimension of cybersecurity is highlighted in the protocols surrounding the discovery and disclosure of vulnerabilities. Ethical responsibilities mandates that findings be reported to system administrators to facilitate timely remediation, where necessary responsible disclosure to the public aims to protect the wider community by prompting broader awareness and action. So, as we see that there is the law books, basically, which gives you a fine if you don't respect them, then the industry standards, okay? These two forces basically works on the idea of negligence or strict liability in working with the laws and the security standards. Then there are the idea from the private sector will be the CIA principles and the other pillars that are developed normally inside the cybersecurity framework of a private company. But on the other side, there is even the cost to security ratio that needs to be taken into consideration, remembering that full compliant security is practically a mirage in the contemporary world. And finally, there's even an ethical dimension that needs to take into consideration as a feature of cybersecurity. That is even the broader engagement with the broader community of users worldwide. So we talk about the principle that governs cybersecurity, how it is defined in different laws, UK, US, and so on, and what are the consequences for not having such principle in place. Another component is the communication, as we said, and engagement towards a broader community. So the idea of notifying the user. So there is a discussion around the breach notification laws, which underscore both time and its criticality, given the central role that data infrastructure plays in the modern society. These laws, which had spread globally, are originating from academic circles and continue to demand rigorous evaluation for their effectiveness and impact. The rationale behind these laws is multifaceted, involving the protection of individuals' privacy, maintaining public trust in digital systems, and encouraging better security practices among data handlers. The dynamic flow of these regulations across borders highlights the need for an international perspective on data security and privacy. Breach notification laws form a part of a broader legal ecosystem aimed at protecting personal data. They are grounded in the intuitive principle that individuals and entities deserve to know when their personal information has been compromised. These laws are not standalone. They interact with various data protection and privacy law, creating a comprehensive framework for data security. The primary justification for breach notification laws is to empower individuals to take protective action in the event of a data breach that might compromise their personal information. Moreover, these laws aims to hold organizations accountable for their data handling and security practices. The interaction between breach notification laws and other data protection regulation creates a layered defense against misuse of personal information and seeks to enhance organizational accountability and transparency. Breach notification laws are not without their challenges. Internally, organizations grapple with the logistics of compliance, including determining when a breach is significant enough to warrant notification and managing the aftermath of a breach. Externally, these laws must balance the public's right to know against the risk of causing unnecessary panic or providing information that could further compromise data security. Policymakers should consider several factors to enhance the effectiveness of breach notification laws. Clearly define, first of all, what constitutes personal information and a data breach to avoid ambiguity that could hinder compliance efforts. Then, establish guidelines on who must be notified, including potentially affected individuals, relevant governmental bodies, and the public. and what information the notification must contain. This ensures that all stakeholders are adequately informed without compromising security further. Then there shall be even exception or threshold for notification to avoid overburdening organization with minor breaches that pose no significant risk to individuals. However, these exceptions should not be carefully calibrated to ensure they do not undermine the law's protective goals. Breach notification laws rest on an intuitive foundation but are complex in their implementation. They are influenced by underlying normative values that prioritize individual privacy and organizational transparency. In designing breach notification law, policymakers must address several critical questions. First of all, as we say, the scope of what is considered personal information directly impacts the breadth of breach notification laws. Expanding this definition may increase the number of notifications, while too narrow a definition may leave individuals unprotected. Determining then what constitutes a breach significant enough to trigger notification is crucial. This includes assessing the nature of the data involved and the potential harm to individuals. 3 is then deciding who needs to be notified, involves balancing the need for public awareness with the risk of causing undue alarm. This decision affects not only the immediate response to breach, but also long-term trust in data handling entities. As we said before, there should be exceptions to notification requirement, and it is essential to avoid dilution, the effectiveness of the laws with too frequent or unnecessary alerts. However, exceptions must be carefully crafted to maintain the protective intent of the legislation. In sum, breach notification laws serve as a critical component of the data protection landscape, balancing the need for transparency and accountability with the practical consideration of implementation. As digital infrastructure becomes increasingly integral to our society, the evolution of these laws must reflect a deep understanding of the technological, ethical, and societal dimension of data breaches. So we spoke of the breach of notification in general, but now we're going to see them in relation with the European legal framework, US legal framework, and UK legal framework. So the discussion of breach notification within the framework of the General Data Protection Regulation, so the GDPR, and its application in the context of cybersecurity and data protection law provides a compelling example of how legal frameworks strive to balance the protection of personal data with the reality of cybersecurity threats. The GDPR, as a leading piece of legislation in the field of data protection, offers a nuanced approach to what constitutes a data breach and outlines the responsibility of data controllers in the event of such breaches. This framework is tested and elucidated through the cases like VB versus Nacionalna Agencja za Prihodite, shedding light on the practical application and judicial interpretation of this law. Under the GDPR, personal data encompasses a wide range of information consistent with general data protection law as outlined in Article 4.1. Article 4.12 defines a personal data breach as any event leading to the accidental or unlawful destruction, loss, alteration, or unauthorized disclosure of or access to personal data. This broad definition prompts a debate on the threshold for notification, especially concerning mere access without a clear evidence or misuse or harm. Now let's go with the case study we mentioned above. So the case of VB versus Nacionalna Agencja za Prihodite before the Court of Justice of the European Union (CJEU) on December 14, 2023 serves as a pivotal example of applying GDPR principle in the wake of cybersecurity incidents. Following a cyber attack on the Bulgarian National Revenue Agency, which affected over 6 million individuals, the case raised significant questions regarding the agency's obligation under GDPR Articles 51F, 24, and 32. The CGEU's ruling provides a critical insight into the interpretation of the GDPR in the context of data breaches and cybersecurity. The court clarified that unauthorized disclosure or access to personal data by a third party does not automatically imply that the data controller's technical and organizational measures were inappropriate under Article 24 and 32. This interpretation suggests that breach incidents, while undesirable, are not in themselves proof of negligence or failure to protect data adequately. It was emphasized then that the adequacy of security measures should be assessed concretely, taking into account the specific risk associated with the processing activities. This means evaluating the nature, content, and execution of the implementation measure related to those risks under Article 32. Importantly, the principle of accountability under Article 5(2) and Article 24 requires the data controller to prove the appropriateness of the implemented security measure. In action for damages under Article 82, this burden of proof lies with the controller, aligning with the broader principle of accountability inherent in the GDPR. The court also stated that while an expert's report could be valuable in assessing the appropriateness of security measures, it should not be seen as a systematically necessary or sufficient means of proof. This underscores the flexibility in proving compliance and the need for a comprehensive evaluation of all evidence related to security measures' effectiveness. The GDPR's, in this way, breach notification requirements coupled with the CGEU's ruling in cases like VB versus Naționalna Agenția za Prihodite underscore a sophisticated legal approach to handling and responding to data breaches. This approach balances the need for rigorous data protection with the realities of cybersecurity risk, emphasizing a nuanced assessment of security measures, accountability, and the evidentiary process in determining compliance. Such legal frameworks and judicial interpretation serve as critical guides for organizations navigating the complex landscape of data protection and cybersecurity. So we have seen the requirement of the notification, right? In the of notification and so on in regards to the notification of breach, right? And the breach of notification is therefore pivotal in the GDPR and its full assessment. So the GDPR though outlines even specific requirements for breach notification to both supervisory authority and affected data subject to ensure that personal data breaches are managed transparently and effectively. Under Article 33 of the GDPR, organization must notify the appropriate supervisory authority of a personal data breach within 72 hours of becoming aware of it, unless they can demonstrate that the breach is unlikely to result in a risk to the rights and freedoms of individuals. The notification must include detailed information about the breach, including its nature, the categories, and approximate number of data subjects and data records affected, the likely consequences of the breach, and the measure proposed or taken by the organization to address and mitigate its effects. If necessary, this information can be provided in phrases as more details become available. Article 34 instead mandates direct communication with the affected data subjects without undue delay if the breach poses a high risk to their rights and freedoms. The communication must be in clear and plain language. There are exceptions to this requirement, such as when the affected data has been adequately encrypted or other measures have been taken to ensure that the high risk to the individual's rights, the freedom is unlikely to materialize. Alternatively, if contacting each affected data subject would involve disproportionate effort, public communication or a similar effective measure may be used, the supervisory authority may also order the organization to notify affected individuals if it hasn't already done so. Non-compliance with these notification requirements can result in substantial fines under Article 83(4)(a) of the GDPR, highlighting the importance of adherence. Fines are assessed based on the severity and nature of the breach, among other factors. The GDPR emphasizes the need for organizations to have advanced plans and measures in place to deal with data breaches effectively. This is under Recital 87. This includes implementing appropriate technological and organizational measures to enable prompt identification, assessment, and reporting of breaches. Effective monitoring and reporting mechanisms are critical components of an organization's data protection strategy. The emphasis on breach notification has also led to the growth of a specialized industry around data protection and compliance, with consulting and accounting firms offering services to help organizations meet GDPR requirements and manage their data protection obligations effectively. Overall, this provision aims to enhance the protection of personal data within EU by ensuring that both authorities and individuals are informed promptly of breaches, thereby enabling timely and effective responses to mitigate any potential harm. We have seen that GDPR had been shaped not only by the regulator but even by the European Court of Justice, but we have even the work by the WP29, Article 29 Working Party, now replaced by the European Data Protection Board, or the ADP, that we're going to see in the next slide. Their opinion on GDPR breach notification requirement emphasize the importance of understanding and addressing confidentiality, integrity, and availability losses. These principles are foundational to data protection and are crucial in assessing the impact of data breaches. Confidentiality losses refer to unauthorized access to or disclosure of personal data. A common scenario raised in question under the GDPR involves the loss of laptops or USB keys that are not encrypted. According to WP29 guidance, such losses should be reported even if it's uncertain where the data has been accessed or disclosed, highlighting the importance of preventive measures like encryption to protect data confidentiality. Integrity losses instead occur when there is unauthorized or accidental alteration of personal data. This undermines the accuracy and trustworthiness of the data, potentially leading to incorrect decision or action based on the tampered information. In the digital realm, this could relate to altered financial records or personal details, while in a physical context it could involve the manipulation of written records. Finally, availability losses cover situations where data is rendered inaccessible or destroyed, such as through a cyber attack that encrypts data and makes it unreachable without a decryption key. The WP29 highlights specific scenarios like losing the key to encrypted information as example where the availability of data is compromised. This impacts the ability of individuals or organizations to access critical information, which could have significant operational and personal consequences. The discussion around data breaches is not limited to digital data. Low-tech examples such as the theft of paper files are also covered under GDPR. consideration. The WP29 notes that stolen paper files can lead to dire consequences, emphasizing the need for physical security measures. Mitigation strategies might include using coding systems to anonymize data and employing physical security measures to protect the locations where such data is stored. This approach underscores that data protection principles apply to all forms of data, not just digital, and that organizations must adopt comprehensive security practices. These guidelines from the WP29 EDPB illustrate the broad scope of data protection under the GDPR, which encompasses both high-tech and low-tech data handling scenarios. Organizations are encouraged to implement preventive measures such as encryption and physical security to minimize the risk of data breaches. Moreover, the guidance on breach notification emphasizes a proactive stance in dealing with potential data security incidents, advocating for transparency with supervisory authorities and affected individuals where risks to their rights and freedoms are identified. This principle and the nuanced approach recommended by the WP29 reflects the GDPR's comprehensive coverage of data protection, highlighting the need for organizations to consider a wide range of security measures to safeguard personal data in all its forms. Another important piece of legislation in the European Union which links data protection with cybersecurity are the European Data Protection Board, the EDPB, guidelines of January 2021, which offer a detailed framework for understanding and managing different types of personal data breaches under GDPR. These guidelines categorize breaches into three primary types: confidentiality, integrity, and divability breaches, each with its unique implication and required response strategy. The confidentiality breach are the type of breach which involve unauthorized or accidental access to or disclosure of personal data. The primary concern here is the exposure of data to parties not intended to see it, potentially leading to risks like identity theft, fraud, or other harms to the data subject's privacy and rights. Integrity breach instead occurs through unauthorized or accidental alteration of personal data. This can compromise the accuracy and reliability of data, affecting decision-making processes, leading to misinformation or causing other material or non-material damage to individuals whose data has been altered. Availability breaches encompass situations where there is accidental or unauthorized loss of access to or destruction of personal data. Such breaches might not involve any unauthorized access or alteration, but can severely impact data subjects by preventing access to critical services or information. The EDPB emphasizes the significant consequences these breaches can have, highlighting the need for data controllers to thoroughly assess the risks to individual rights and freedoms and to take appropriate measures to prevent or mitigate these risks. For instance, breaches involving ransomware typically require notification due to their impact on the availability and potentially the confidentiality of personal data. The guidelines also address data exfiltration attacks, emphasizing their potential to compromise confidentiality and occasionally data integrity. The guidelines further stress the importance of having robust procedures and training in place for handling data breaches, including the necessity for data controllers to document breaches comprehensively. This documentation should support an effective response and compliance with GDPR requirements, which may include notifying the competent supervisory authority (SAs) and the affected data subjects, depending on the breach's likelihood and severity of resulting risks to individual rights and freedom. In the wake of the breach, data controllers are encouraged to take swift action, assessing the risk to individuals promptly without waiting for a detailed forensic analysis. Early and effective response measures, as well as transparent communication with SAs, can be crucial in mitigating the damage and fulfilling the GDPR's requirement. For more in-depth guidance, a specific example, the guidelines are invaluable resource, providing case-based insights derived from the collective experience of EU data protection authorities. So we have seen the EU framework, and now we're gonna see the US one. We're gonna start from a general overview, but I'm gonna basically to talk about state by state data breach notification, right? Because that's important, as we have seen, in order even to get the understanding in relation to cybersecurity. Okay, so understanding and adhering to data breach notification requirements across the US present a formidable challenge due to a mosaic of state-specific law, with each of the 50 states enacting its own legislation. Variations abound in aspects like the threshold for reporting incident, timelines for notification, the precise definition of what constitutes personal data, and the specific circumstances that trigger this law. For example, New York mandates notification for all data breaches involving unencrypted information, showcasing a relatively low threshold for reporting. In contrast, other states necessitate notification only when there is a substantial likelihood of harm to the individual impacted. The timelines set by states for notifying affected parties can vary, typically falling between 30 to 60 days after discovering a breach. The definition of personal data also lacks uniformity across jurisdictions, adding another layer of complexity for organizations operating in multiple states. The laws are commonly activated by unauthorized data acquisition, though in some cases mere data exposure without direct acquisition could also necessitate reporting. Organizations face the pressing need to remain vigilant and keep abreast of these ever-evolving statutes to effectively prepare for and respond to data breaches. This includes grasping not only the foundational notification requirements applicable to data owners, but also understanding the exception and specific detail concerning how notifications should be conducted and what they must include. While some states afford safe harbors for encrypted data, others extend protection to data deemed public or otherwise unreadable or unusable. Additionally, compliance with federal laws like HIPAA or the Gramm-Leach-Bliley Act may influence or exempt entities from certain state notification requirements. Okay. At the core, data breach notification laws across the various United States share a common goal to ensure timely and effective communication to individuals whose personal information has been compromised. However, the threshold for what constitutes a breach and the timeline for notification can significantly vary. For example, some states require immediate notification once a breach is discovered, with a specific deadlines ranging from as few as 30 days to as many as 60 days post-discovery for notifying the affected parties. The variances in state laws also extend to exception and specific requirements for how notification should be conducted. For instance, many states offer a form of safe harbor from notification requirements for data that was encrypted at the time of the breach. The rationale is that encryption reduces the risk of harm since the data should be unreadable without the description key. Some jurisdictions instead may not require notification for data breaches involving information that is already publicly available or data rendered unreadable or unusable through means other than encryption, such as redaction. The content required in the notification itself can vary, with some states mandating the inclusion of specific information about the breach, what data was involved, and what steps individuals can take to protect themselves. Similarly, the approved methods for delivering this notification, written notice, electronic notice, substitute notice when direct contact is impracticable, can differ. Federal laws like the Health Insurance Portability and Accountability Act HIPAA and the Gramm-Leach-Bliley Act GLBA play a significant role in shaping an organization breach notification protocol. The HIPAA applies to covered entities and their businesses associated in the healthcare sector, mandating specific privacy and security measures to protect health information. Organizations compliant with HIPAA may find that certain state notification requirements are preempted or complemented by federal obligation. GLBA affects financial institutions, requiring them to protect the security and confidentiality of customers' personal financial information. Compliance with the GLBA can similarly influence the applicability of state-level notification requirements, with some states considering adherence to GLBA as fulfilling state law requirements. Organizations must stay informed and adaptable, leveraging legal counsel and compliance expertise to navigate these regulations effectively. Tools like compliance matrices and consulting services can provide valuable assistance in understanding and meeting these obligations. Washington's data breach notification laws, as detailed in section like Washington Revised Code section 19.255.010 at Sequitur, and further amendments through bills such as SB 6043, HB 1149, HB 1078, and HB 1071 present a comprehensive approach towards the management and notification of data breaches. This law applies to any entity that conducts business within Washington states and owns or licenses computerized data containing personal information (PI). A security breach is defined as unauthorized acquisition of data that compromises the security, confidentiality, or integrity of PI maintained by the entity. Notably, good faith acquisition by employees for the entity use are not considered breaches if the PI isn't subject to further unauthorized disclosure. Entities are obligated to disclose any breach to Washington residents whose PI was likely acquired by an authorized person, notably PI that is secured, meaning encrypted to NIST standard, or made unreadable or undecipherable, is exempt unless the means to decrypt or decipher the PI were also compromised. Notification is not mandated if there is no reasonable risk of harm consumers. For breaches affecting more than 500 Washington residents, entities must also notify the state attorney general, providing specifics like the number of affected consumers, types of compromised API, the breach and discovery dates, and measures taken to contain the breach. Entities maintaining data not owned by them must notify the PI's owner or licensee if a breach occurs. This ensures that the responsible entity can take appropriate action to notify affected individuals. Notification to individuals and the Attorney General must occur expediently within 30 days of breach discovery, barring any law enforcement delay. Methods of notification include written or electronic communication, with substitute notice allowed under certain cost or scale threshold. The law defines PI in a detailed manner, including but not limited to names combined with social security number, financial account information, or other identifiers that could facilitate identity theft. It expands to include email or username combination with password or security questions that allow online access. The statutes acknowledge compliance with federal laws like the Gramm-Leach-Bliley Act (GLBA) or the Health Insurance Portability and Accountability Act HIPAA as fulfilling state requirements, particularly concerning notification protocol. Non-compliance with these laws allows the Attorney General to enforce action on behalf of the state or affected residents, emphasizing the legal imperative for entities to adhere strictly to this regulation. Washington's progressive updates to its data breach laws reflect an evolving understanding of the risk and necessity of digital information security. The inclusion of reimbursement mandates for financial institutions in case of breach-related card replacements and the explicit requirement for Attorney General to notification underscores a commitment to consumer protection and corporate accountability. The state's detailed approach serves as a model for comprehensive and responsive data breach legislation, addressing both the immediate impacts of breaches and the broader need for synthetic security improvements. Oregon's data breach notification law were established and updated through a series of Senate bills and delineate a comprehensive requirements for entities in the event of a data breach. These laws are codified under Oregon Rev Stat Section 646A, 646A from 600 to 626 and apply to any individual or entity, including public bodies that own license or otherwise possess personal information (PI) in the course of their business activity. Oregon defines a security breach as the unauthorized acquisition of computerized data that materially compromises the security, confidentiality, or integrity of the PI. Private information, notably inadvertent acquisition by an entity, its employees or agents, are not considered breaches if the PI is not used, unlawful, and not subject to further unauthorized disclosure. Entities must notify a customer whose PI has been compromised. This obligation is waived if, after a thorough investigation and consultation with law enforcement, the entity determines the breach is unlikely to harm the individuals whose PI was accessed. Such determination must be documented and retained for 5 years. For breaches affecting more than 250 Oregon residents, entities must notify the Attorney General. Additionally, if over 1,000 individuals are notified of the breach nationwide, the Consumer Reporting Agency must also be informed, which helps protect affected consumers from potential identity theft and fraud. Entities possessing PI on behalf of another must notify the PI owner within the 10 days of discovering a breach. If the breach affects more than 250 residents, or if the extent of affected residents cannot be determined, these third parties must also notify the Attorney General, unless the primary entity has already done so. Notification to affected consumers and the Attorney General should occur as quickly as possible within 45 days after the breach discovery to ensure timely protection of those impacted. Oregon definition of PI is broad, encompassing data such as social security number, driver's license number, financial account information, biometric data, medical history information, among others. The law aims to protect a wide range of sensitive consumer data that could be exploited if accessed by unauthorized parties. Notices to affect individuals must include a general description of the breach of the type of PI compromised and advice on protecting against the identity theft. Notification can be made in writing, by telephone, or electronically, depending on the entity's primary communication method with the consumer. Entities offering credit monitoring services following a breach cannot require affected individuals to provide payment information as a condition for receiving these services. This provision ensures that victims of a breach are not further burdened financially. Entities complying with federal laws like the Gramm-Leach-Bliley Act or the IPAA, or those following stricter state or federal regulation, may be deemed compliant with Oregon's notification requirements, although they must still notify the Attorney General if more than 250 residents are affected. Oregon's approach to data breach notification emphasizes the protection of consumers' privacy and the integrity of personal information. The laws mandate swift action and transparency from entities in the aftermath of a breach, aiming to mitigate potential harm to individuals and reinforce the importance of robust data security practices. California's data breach notification law codified in Kelsey Code 1790.29 and 1790.82 et sequitur have evolved through several legislative amendments to bolster privacy protection and notification requirements for California residents. The status applies broadly to any individual or entity, including state agency, that conducts business in California and owns legislative computerized data containing personal information (PI). Entities responsible for data do not own but maintain, store, or process are also covered, highlighting comprehensive approach to data stewardship. A security breach is defined as the unauthorized acquisition of computerized data compromising the security, confidentiality, or integrity of PI. Notification obligations are triggered not only by breaches involving an encrypted PI, but also encrypted PI if the encryption key or security credential is also compromised, posing a risk that the encrypted PI could be rendered readable or usable. Entities are mandated to notify affected California residents in the most expedient time possible and without unreasonable delay, particularly when there's a reasonable belief that an unauthorized acquisition of PI has occurred. This prompt notification required is subject to legitimate law enforcement needs or necessary measures to determine the breach scope and restore data system integrity. For breaches affecting more than 500 California residents, entities must also notify the California Attorney General, providing a sample copy of the notification, excluding personal identifiers. Additionally, if more than 1,000 individuals are notified of a breach, nationwide consumers or broadcasters must be informed, facilitating broader protective measures for affected individuals. California's laws define PI in detail, encompassing data from social security numbers and financial accounts to biometric and genetic data. The required content of breach notification is similarly specified, including a general description of the breach, the types of PI involved, and advice on steps individuals can take to protect themselves from potential identity theft. For breaches involving online account credentials, specific guidance is provided on notifying affected individuals, including instruction for securing their accounts. Importantly, if credit monitoring services are offered, they must be provided free of charge for a significant period, enhancing post-breach consumer protection. Civil penalties and private right of action exist for violation of the status, underscoring legal implication for entities failing to comply with California's data breach notification law. This legal framework not only seeks to remedy the immediate effects of data breaches, but also to incentivize stronger data protection measures by entities operating within California. California's approach reflects a dynamic response to the challenges of data security in the digital environment, emphasizing transparency, accountability, and consumer protection in the wake of data breaches.
Mi do una sciacquata e devo ripartire tra un quarto d'ora. Vuoi vedere il video con me? Ti va?
Sì, un attimo solo.
Cos'è che stai?
The covered entities in Nevada are government agencies, education institutions, corporations, financial institutions, and other businesses that own or license computerized data containing personal identifiable information, the PI. The security branch is defined as unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of PI. Entities must disclose breaches to Nevada residents whose unencrypted PI was acquired by an unauthorized person. If notification is required for more than 1,000 persons, nationwide consumer reporting agency must also be notified. Entities must notify the owner or licensee of PI if they maintain data they do not own and a breach occurs. Notification must be made without unreasonable delay, considering measures necessary to determine the breach scope and restore system integrity. Personal information includes various data elements like social security number, driver's license number, account numbers, and unique identifiers. The notice method are through written or electronic notice, and substitutes notice is available if the cost of running notice exceeds $205,000 or if contact information is insufficient. There are exceptions. Compliance with other laws like Graham-Leach-Bliley Act exempts entities from notification requirement. Notification may be delayed if law enforcement determines it would impede a criminal investigation. Then violators may face civil action, restitution, or injunction. Data collectors can recover damages, including attorney fees and notification costs from unauthorized persons. The Attorney General or County District Attorney can take legal action against the violator. Okay, so in IDAO instead, the covered entities are any agency, individual, or commercial entity conducting business in IDAO that owns or licenses computerized data containing personally identifiable information, so the PI about an IDAO resident. The security breach is considered as an unauthorized acquisition of unencrypted computerized data, compromise the security, confidentiality, or integrity of PI maintained by the entity. Entities must notify affected IDAO resident as soon as possible. Notification is not required if a good faith investigation determines that the PI has not and will not be misused. Entities must notify and cooperate with the owner or licensee of the PI if the entity maintains data it does not own or license and misuse of PI occurred or is likely to occur. Notice must be given in the most expedient time possible and without unreasonable delay. Personal information definition includes first name, initial, and last name combined with social security number, driver's license, or state ID number, or financial account access information when unencrypted. Written telephonic or telephonic notice is acceptable. Substitute notice is available if the cost of providing notices exceeds $25,000, the number of residents exceeds 50,000, or contact information is insufficient. Compliance with other laws or internal notification policies may exempt entities from certain requirements. Intentional failure to give notice may result in a fine up to $25,000 per breach. Primary regulators may enforce compliance through civil action then. The Utah Code outlines specific regulation and procedures for managing and responding to security breaches involving personal information (PI). The legislation mandates that any entity, whether they own or license computerized data that includes PI of Utah residents, must adhere to this regulation to protect the integrity, confidentiality, and security of such information. Here is a summary. The security breach is defined as the unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of PI. However, acquisition of PI by an employee or agent for lawful purposes is not considered a breach unless the PI is used for unlawful purposes. Entities must conduct a prompt investigation if they suspect a breach. If the investigation reveals that PI misuse for identity theft or fraud has occurred or is likely to occur, they must notify each affected Utah resident. The notification is not required if, after a good faith investigation, the entity determines the PI has not been and likely will not be misused. If a breach affects 5,500 or more Utah residents, the entity must also notify the Office of the Attorney General and the Utah Cyber Center. For breaches affecting 1,000 or more residents, notification to each nationwide consumer reporting agency is required. Entities that maintain but do not own or license the PI must notify the owner or licensee about any breach if misuse of the PI occurs or is likely to occur. Notification to affected individuals must be made as quickly as possible without unreasonable delay following the determination of the breach scope and the restoration of the system's integrity. Personal information PI includes an individual's first name or initial and last name combined with sensitive data elements like social security number, driver's license or ID card number or financial account numbers, provided the data is unencrypted or not otherwise protected. Notification can be made via first-class mail, telephone, or electronically if it is the entity's primary communication method with the resident, or by substitute notice if direct notification is not feasible, such as through newspaper publication. Entities with their own authentication policies or those regulated by state or federal law are deemed compliant if their procedures meet the chapter's requirement. Violators can face civil fines up to $2,500 per violation, up to $100,000 in aggregate for multiple violations. This comprehensive legislative framework aims to ensure timely and effective communication to individuals affected by data breaches, thereby allowing them to take necessary action to protect themselves from potential identity theft or fraud. It is also underscored the importance of maintaining high standards of data protection and security practices among entities handling the PI of Utah residents. Arizona data breach notification laws, as laid out in Arizona relevant statute section 18551 et sequitur, offer a comprehensive framework for managing and responding to data breaches that compromise the security or confidentiality of personal information. Is an overview. The laws apply to any individual or entity referred to collectively as entity that conducts business in Arizona that owns, maintains, or licenses an encrypted and unredacted computerized PI. And the security breach is defined as an authorized acquisition of and access to an encrypted and unredacted computerized PI that materially compromise the security or confidentiality of PI maintained as part of a database of PI regarding multiple individuals. Good faith acquisition of PI by an employee or agent for the entity's purposes, provides the PI is not used for a purpose unrelated to the entity or disclosed further, does not constitute a security breach. Entity must notify affected individuals within 45 days after determining that a security breach has occurred, unless reasonable investigation concludes that the data breach is not likely to result in substantial economic loss to affected individuals. If a breach affects more than 1,000 Arizona residents, the entity must also notify the Attorney General and the three largest nationwide consumer reporting agencies. Entities that maintain but do not own or license the PI must notify the owner or licensee of the information as soon as possible and cooperate with them by sending information relevant to the breach. PI includes an individual's name combined with other sensitive data elements such as social security number, driver's license or ID card number, financial account numbers, private keys, health insurance ID, medical information, passport number, taxpayer ID, biometric data, and online accounts credential. Notification can be provided through written notice, telephonic notice, or email notice and must include the breach, approximate date, the type of PI included, contact information for the largest credit reporting agency, and the resources for identified theft protection. Entities with their own notification policies or those subject to other regulation like Gramm-Leach-Bliley Act or HIPAA are deemed compliant if they notify affected individuals according to their policies or the other applicable regulations. A willful violation of these provisions can lead to penalties enforced by the Attorney General not exceeding $10,000 per affected individual or $5,000 in total. This law reflects Arizona's commitment to protecting residents from the fallout data breaches by ensuring timely and effective notification response measures. They balance the need for prompt consumer protection with realistic provision for entities managing the complexities of data security and data breach response. Colorado's data breach notification law, outlined in Color Revstat Section 61716, impose obligation on individuals or commercial entities referred collectively as entities that conduct business in Colorado and possess, license, or maintain computerized data including personal information (PI). Here's a summary of the legislation's key aspects. The laws apply to any entity conducting business in Colorado that handles computerized containing PI. A security breach is defined as the unauthorized acquisition of unencrypted computerized data that compromise the security, confidentiality, or integrity of PI. Good faith acquisition by employees or agents for legitimate business purposes, provided there's no further unauthorized use, are not considered breaches. Entities aware of a breach must notify affected Colorado residents as quickly as possible. Notification isn't required if, after investigation, the entity determines there's no reasonable likelihood of harm to the affected individuals. If more than 500 Colorado residents are affected by a breach, the entity must also notify the Colorado Attorney General within 30 days of the breach determination. Entities needing to notify over 1,000 Colorado residents must inform all major nationwide
consumer reporting agency without undue delay. Entities that maintain but do not own PI must inform the data owners or licensee about any breach likely to misuse PI concerning Colorado residents. Notification must occur as quickly as possible and no later than 30 days after confirming a breach occurred, ensuring any necessary measure to ascertain the breach scope and secure the data system are considered. PI includes a Colorado resident first name or initial and last name in combination with sensitive data elements like social security number, financial account information, medical information, or online account credentials, provided these are not encrypted, redacted, or otherwise secured. Notice to affected individuals can be given via written notice, telephone, or electronic means, depending on the entity primary's mode of communication with individuals or consistency with federal electronic records law. Available under specific circumstances, the substitute notice is, for example, when direct notice costs would exceed $250,000. The affected class include more than 250,000 Colorado residents or insufficient contact information exists. It involves email notification, website posting, and media alerts. Entity with their notification policies as part of an information security policy deemed consistent with Colorado's timing requirements are considered compliant. And the same applies to entities covered by the Gramm-Leach-Bliley Act. Notification can be delayed at a law enforcement agency's request if it would impede a criminal investigation. The Colorado Attorney General has the authority to enforce these regulations, seeking direct damages and injunctive relief for non-compliance. This framework aims to ensure the rapid and effective communication of data breaches to affect Colorado residents, allowing them to take appropriate steps to protect themselves from potential harm resulting from unauthorized data access. Texas Data Breach Notification Law, codified under Texas Bus and Com Code sections 521.002 and 5.1.053, detail the obligation of entities that experience a breach of system security involving sensitive personal information, PI. The laws apply to any person or entity, collectively referred as entity, that conducts business in Texas and owns licenses or maintains computerized data that includes sensitive PI. A security breach is the unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of sensitive PI. These include breaches involving encrypted data if the encryption key has also been obtained. Entities must disclose any breach of system security to an individual, including non-residents whose sensitive PI was or is reasonably believed to have been acquired by an authorized person. Entities must notify the Texas Attorney General of any breach affecting at least 250 Texas residents as soon as practicable and no later than 30 days after determining that a breach has occurred. The notification must include a detailed description of the breach, the number of affected residents, and measures taken or planned in response to the data breach. If a breach necessitates notifying more than 10,000 individuals, entities must also inform all nationwide consumer reporting agency about the time and distribution and content of the notices. Entities that maintain computerized data containing sensitive PI they do not own are required to notify the owner or licensee of the information about any security breach in a timely manner. Notification to individuals must be made as soon as practicable, generally no later than 60 days from the discovery of the breach, unless delayed to determine the breach scope, restore data system integrity, or due to law enforcement needs. Sensitive PI includes an individual's first name or first initial and last name combined with social security numbers, driver's license, or government-issued ID numbers, financial account numbers, or other specific data elements related to identity, health, or financial information. Notice can be provided through written notice or electronic notice consistent with the Federal E-Sign Act, unless the individual is a resident of a state with its own breach notification requirements. Available if direct, the substitute notice is available if direct notice cost would exceed $250,000 to $500,000. The number of individuals to be notified exceeds 500,000, or the entity lacks sufficient contact information. Substitute notice may include email, web posting, and statewide media notification. Entities with their own notification procedure as part of an information security policy that comply with the timing requirements are deemed in compliance if they notify affected individuals according to their policy. The Texas Attorney General may enforce the laws with remedies including injunctive relief and civil penalties ranging from $2,000 to $50,000 per violation. For notification failures, penalties can reach up to $1,000 per individual per day, capped at the $250,000 per breach. Kansas data breach notification laws found in CANSTAT section 57A01 at Secyrity establish protocols for notifying Kansas residents in the event of unauthorized access to their personal information. These laws apply to any individual or entity, including government entities, that own or license computerized data containing PI of Kansas residents. The legislation covers any individual, legal, or government entity conducting business in Kansas that owns or licenses computerized data, including PI. A security breach is defined as unauthorized access and acquisition of unencrypted or unredacted computerized data that compromises the security, confidentiality, or integrity of PI and is likely to cause identity theft or fraud. Entities aware of a breach must promptly investigate. If the investigation concludes that PI misuse is possible, they must notify affected Kansas residents without unreasonable delay. Entities maintaining data they do not own must inform the data owner or licensee about any breach if PI was assessed or is believed to have been assessed by an unauthorized person. Notification to affected individuals should be as quick as possible, considering the need to determine the breach scope and restore data system integrity, but no specific timeline is provided in the summary. Law enforcement can delay notification if it impedes an investigation. PI includes a consumer first name or first initial name and last name combined with sensitive data elements like social security numbers, driver's license, number, or financial account information when not encrypted or redacted. Notice can be delivered through written, telephonic, or electronic methods, with electronic notice requiring consistency with Federal e-Sign Act provisions. The substitute notice is available if direct notice cost exceeds $100,000, the affected class is larger than 5,000, or sufficient contact information is lacking. It involves email, website posting, and major statewide media notification. Entities with their notification procedures or those complying with regulation established by the primary or functional regulator are deemed in compliance. Specific guidance is provided for financial institutions and entities subject to federal regulations. The Kansas Attorney General has the authority to enforce these laws, with specific provision for actions involving licensed insurance companies to be handled by the Insurance Commissioner. The Attorney General can take legal action to ensure compliance, secure injunctive relief, and enforce penalties for violation. For insurance companies, the Insurance Commissioners hold enforcement authority. The Illinois Personal Information Protection Act outlines comprehensive measures for handling personal information and addressing data breaches. Here are key aspects of Illinois' data breach notification laws. This law applies to any entity that handles, collects, disseminates, or deals with non-public personal information (PI) of Illinois residents, regardless of whether the entity's primary place of business is in Illinois. A security breach is defined as the unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of PI maintained by the entity. Good faith acquisition by an employee or agent for the entity's purposes, provided the PI is not used unlawfully or disclosed further, does not constitute a breach. Entities must notify affected Illinois residents promptly after discovering a breach or being notified of one without unreasonable delay and in the most expedient time possible. Notification can be given in writing or electronically, provided it is consistent with the E-Sign Act. If the breach affects more than 500 Illinois residents, the entity must also notify the Illinois Attorney General detailing the nature, timing, and number of residents affected. Entities that maintain or store PI on behalf of another must notify the owner or licensee of the data immediately upon discovery of a breach. Notification to individuals must include contact information for customer reporting agency and the Federal Trade Commission, along with the advice on how to obtain information about fraud alerts and security freezes. The notification should not disclose the number of residents affected by the breach. For breaches involving online account credentials, entity can provide electronic or other forms of notice advising residents to change their username, passwords, and security question and answers. If the cost of direct notification substitute notice is available, if the cost of direct notification exceeds $250,000, affects over 500,000 residents, or sufficient contact information is unavailable. Entities in that case may use substitute notice methods, including email notification, posting on their website, and notifying major statewide media. Entity compliant with more stringent federal laws like HIPAA are considered in compliance with Illinois law, provided they also notify the Illinois Attorney General if required by federal law. Notification may be delayed if a law enforcement agency determines that it will impede a criminal investigation. Violation of the statutes are treated as unlawful practices under the Illinois Consumer Fraud and Deceptive Business Practices Act. The Illinois Attorney General can enforce penalties, including civil penalties up to $50,000 per violation, with additional penalties for actions intended to defraud or affecting seniors. Florida's data breach laws are outlined in FLA Stat Section 501171 and encompass a range of requirements for individuals and businesses that acquire, maintain, store, or use covered information. Here's an overview of the key components of these laws. The laws apply to any sole proprietorship, partnership, corporation, trust, estate, cooperative, association, or other commercial entities, as well as governmental entities that handle personal information. A security breach involves the unauthorized access of data in electronic form containing PI. Data breaches do not include situations where the PI is accessed in good faith by an employee or agent of the entity and the information is not used for a purpose unrelated to the business or disclosed further. Encrypted or redacted information is also excluded if the encryption key or redaction method was not compromised. Entity must notify Florida resident whose PI was accessed due to a breach within 30 days of discovering the breach. This notification must include the dates or estimated dates of the breach, a description of the affected information, the steps the entity has taken to address the breach, and what affected individuals can do to protect themselves. Entities must notify the Florida Department of Legal Affairs if the breach affects 500 or more individuals. Notification to consumer reporting agencies are required if more than 1,000 residents are affected. Acceptable methods include written notice, electronic notice if that is the primary method of communication with the affected individual, or substitute notice if direct contact information is unavailable or the cost of providing direct notice is prohibited. Third parties maintaining data on behalf of other entities must notify the entity for whom the data is maintained as soon as practicable after discovering a breach. Non-compliance with the notification requirements can result in civil penalties under the Florida's Unfair or Deceptive Trade Practices Law. The maximum civil penalty for violation is $500,000. Entities are considered in compliance with Florida's law if they are covered by any and comply with federal regulations such as the Graham-Leach-Bliley Act or the Health Insurance Portability and Accountability Act, HIPAA, provided they notify affected Florida residents in accordance with the federal requirements. So, concluding this part about the breach notification, the justification for breach notification laws extends beyond intuitive alignment with the broader disclosure movement, delving into nuanced rationales like deterrence, mitigation, information flows, and autonomy, among other fundamental values. The idea here is that the threat of negative consequences from a breach, such as loss of businesses, reputational damage, regulatory scrutiny, and possibly a dip in stock prices, would motivate firms to bolster their data security measures. However, direct mechanism might already exist that penalizes firms, and the effectiveness of deterrence is debated, especially considering potential underreporting due to fear of consequences. Notification laws serve to protect individuals from the consequences of breaches, such as identity theft, financial loss, or damage to reputation. By informing the affected individuals promptly, they can take protective actions like monitoring credit, changing passwords, or placing credit freezes. Yet the effectiveness of mitigation is contingent on the public's response, which might be dulled by notification fatigue. Mandatory breach notification ensure a flow of crucial information about data security breaches and vulnerabilities, which can aid in patching security holes and shaping security standards. This flow of information is critical both in the immediate aftermath of breaches for containing damage and in the long term for enhancing security protocols across the board. Breach notification respects individuals' right to know and control their personal information. They can also serve a restorative justice function by offering an apology from the breached entity to the affected individuals, potentially including advice on protective measures and taking responsibility for the breach. The principle of deterrence and mitigation might conflict, as strategies that enhance one could undermine the other. For instance, anonymous notification might improve mitigation efforts by encouraging firms to report breaches without fear of excessive penalty, but could dilute the deterrent effect. Furthermore, the applicability and effectiveness of negligence and strict liability in the context of breach notification are complex, given the unpredictable nature of cyber threats and the potentially disproportionate consequences of breaches attributed to nation states' actions. As breach notification laws evolve, the justification and implementation continue to balance between promoting security, ensuring fairness, and protecting individuals, necessitating a nuanced approach to address the dynamic landscape of cybersecurity threats and data privacy concerns. The identification plays a pivotal role in data protection, balancing the need for privacy with the utility of data for analysis, research, and business insights. It's a complex process involving the removal or modification of personal identifiers from datasets to prevent individual identification without stripping the data of its value for legitimate use. The key fields for the identification will be the health and medical, as data here are critical for protecting privacy while allowing research and statistical analysis. Financial data, as the identification ensures individual financial transaction cannot be traced back to the person, maintaining financial privacy. In governmental data, the identification is important for making government data open and accessible while protecting individual privacy. For privacy and data protection, identification is a foundational element across all sectors to comply with privacy law and regulation. Cases, though, like the Massachusetts Public Health Data, AOL, and Netflix underscore the challenges of the identification. They reveal how dataset once thought to be de-identified could be re-identified by linking data with other sources. These instances caution against a simplistic release and forget approach and emphasize the need for ongoing risk assessments and robust data governance frameworks. There are several de-identification strategies. The first one are anonymization techniques that goes beyond just removing obvious identifiers like names and addresses. Effective identification might require the application of statistical method, data aggregation, noise addition, or data fuzzing to mitigate re-identification risk. Tiered approaches is another strategy in which the identification is multifaceted, involving statistical methods, technological safe work such as audit logs and virtual data rooms, legal agreements including data use and transfer restriction, administrative actions like breach response planning and risk assessment, and ongoing vigilance to adapt to new threats. The identification intersects with security, necessitating a procedural approach to manage risk rather than a binary secure, not secure status. Access model range from unrestricted release and forget to controlled access in trusted environment, highlighting the need for tailored solution based on the sensitivity of the data and the context of its use. Synthetic dataset, these are the application of the advanced issue. Generation of entirely new datasets based on the original data characteristics, reducing privacy risk while preserving analytical value. Homomorphic encryption allows for computation on encrypted data, offering a way to work with data without exposing sensitive details. Criminalizing re-identification. Legal frameworks that penalize unauthorized attempts to re-identify individuals from the identified dataset. Differential privacy introduces mathematical guarantees to quantify privacy risk, enabling data use while strictly limiting the chances of individual identification. Identification is not a one-size-fits-all solution, but a nuanced process that requires careful consideration of the specific context, data sensitivity, and potential risk involved. It demands a dynamic approach, blending technological, legal, and procedural elements to safeguard privacy while enabling the valuable use of data. Let's see now how the identification is regulated in the EU and the US. So, in the General Data Protection Regulation, the GDPR, introduced a nuanced approach to personal data, emphasizing the concept of identifiability in Article 4.1. It defines personal data as information related to an identifier or identifiable natural person. A person becomes identifiable if they can be directly or indirectly identified, especially by reference to identifiers like names, identification numbers, location data, or other factors. Recital 26 of the GDPR expands on this by considering the means reasonably likely to be used for identifying an individual, taking into account various factors such as the cost, time, and available technology at the time of processing. The regulation specifies that its rules do not apply to anonymous information, which is data that does not relate to an identified or identifiable natural person, or data rendered anonymous in such a manner that the subject is not or no longer identifiable. Further guidance from the Article 29 Working Party, WP 29, now succeeded by the European Data Protection Board, clarifies that the identification should ensure that identification of the data subject is no longer possible using all the means reasonably likely to be used. The WP 29 sets forth criteria to determine when data is truly anonymized under the GDPR, focusing on whether it is possible to first single out an individual, and second, link records related to an individual, and third, infer information about an individual. These guidance underscore the importance of a comprehensive approach to the identification under GDPR, ensuring that any process used effectively mitigates the risk of re-identification. The GDPR stance on the identification and anonymization reflects a balance between enabling data usage for research, analysis, and business intelligence while upholding individuals' privacy rights. This balance is crucial for organizations that process personal data, necessitating stringent measures to anonymize or de-identify data in compliance with the regulation. The classification of IP addresses, let's continue on the EU identification strategy. So the classification of IP addresses as personally identifiable information (PII) is a nuanced topic with interpretation varying based on the context of use and legal jurisdiction. Static IP addresses are generally considered PII because they can be consistently linked to a specific computer or device, thereby potentially identifying the user of that devices. Dynamic IP addresses, which change each time a device connects to the internet, have been a subject of debate. However, the landmark Breyer decision by the European Court of Justice (ECJ) has set a precedent that dynamic IP addresses can also be considered personal data under certain conditions. The ruling suggested that if a third party has the means to link an IP address with a specific individual and it's reasonable that this information would be used legally, then dynamic IP addresses can indeed be considered identifiable information. This interpretation is particularly relevant in all coding situations, including the transfer of coded information to third parties. Such a stance has implications for the transfer of data, emphasizing the need for robust data protection measures even when dealing with seemingly anonymized or coded data. In the realm of web analytics and tracking, data such as cookie numbers, setting dates, and other behavioral data are increasingly recognized as personal data. The criterion is not whether the data can immediately be linked to a specific natural person, but whether there is the capability to isolate and identify an individual user. This view expands the scope of what is considered personal data, impacting how organizations approach data analytics and the transfer of such data across borders. Additionally, authorities like the European Medicine Agency (EMA), the UK's Information Commissioner's Office, the ECO, and the French National Commission on Informatics and Liberty (CNIL) provide guidance and regulatory oversights on the identification practices and the handling of PII. Notably, cases like GC Deco in France involving MAC addresses highlight the ongoing legal scrutiny and evolving understanding of what constitutes personal data in various contexts. This evolving landscape underscores the importance of considering both static and dynamic IP addresses, as well as other indirect identifiers as potential personal data. Under privacy laws like the GDPR, organizations must stay informed of legal developments and implement data protection practices that account for the broad interpretation of PII to ensure compliance and to protect individual privacy. The approach to de-identification of personal data varies significantly between the United States and other jurisdictions, influenced by different legal frameworks and regulatory guidance. In the US, de-identification is addressed under various federal laws, notably including the Health Insurance Portability and Accountability Act, so HIPAA, in which the privacy rule is that under HIPAA provides two main pathways for the identification of health information. The safe harbor method that involves the removal of specific identifiers of the individuals and of related relatives, household members, and employers to ensure that the remaining information cannot be used to identify the individual. The expert determination method. This approach involves instead a formal determination by a qualified expert that the risk of re-identification is very small. The Federal Trade Commission, the FTC, also plays a significant role in enforcing privacy practices including those related to de-identification through its general authority to prevent deceptive or unfair business practices. The FTC emphasizes that the importance of contractual provisions in data sharing agreements to ensure the protection of consumer data. In the European Union, instead, with the GDPR, there is a whole different approach. The GDPR indeed does not specifically outline the identification methods like the safe harbor or expert determination method. Instead, GDPR focuses on the concept of anonymation and pseudonymation as means of data protection with stringent criteria for what constitutes truly anonymized data, which is no longer considered personal data and is not subject to GDPR. The GDPR places a strong emphasis on the risk of re-identification. Recital 26 of the GDPR specified that the data should be considered identifiable if it is reasonable to expect that a person could be identified directly or indirectly, considering all the means reasonably like to be used. The fundamental difference between the US and EU approaches lies in the specificity of the guidelines and the scope of applicability. The US HIPAA regulation provides clear methods for the identification specific to health information, while the GDPR adopts a broader, more principle-based approach applicable to all personal data types, requiring a case-by-case assessment of the risk of the identification. Moreover, the US framework under the HIPAA allows for some level of interpretation by experts in the field of data protection and privacy, whereas the GDPR demands a rigorous assessment of the risk associated with data processing activities, emphasizing the need for protective measures like pseudonymation and anonymization to mitigate this risk. This comparative overview highlights the nuances and complexities of the identification practices across jurisdiction, underscoring the importance for organizations to carefully navigate the legal requirements and best practices in data protection and privacy. When it comes to the identification, the approach should be multifaceted, considering both the practical aspects of handling data and the ethical implication of its use. Rubinstein and Herzog suggest several critical factors that organizations must weigh in this process. First of all, larger datasets can increase the risk of re-identification, especially if they contain detailed information that can be cross-referenced with other sources. Secondly, the nature of the data matters significantly. Information related to health, financial status, or other sensitive aspects of an individual's life requires more stringent de-identification techniques. Thirdly, who is receiving the data can affect how it should be de-identified. Data shared with a trusted research institution may require different handling than data made publicly available. Fourthly, the intended use of the data can also guide the identification process. If data is to be used for high-risk applications, more rigorous de-identification may be necessary. Fifthly, and finally, this involves the technical and procedural methods applied to identify the data, like encryption or pseudonymation, which can vary in their effectiveness. Limiting access to de-identified data to only those who need it for their work can reduce the risk of accidental or intentional identification. Finally, obtaining consent from individuals whose data is being de-identified and used, particularly for sensitive data, is crucial for ethical governance and may also be a legal requirement. The new NIST document from 2023 further expands on the concept by recommending the establishment of disclosure review boards, DRBs. These boards, composed of legal and technical privacy experts, stakeholders within the organization, and representative of the organization's leadership, can provide a structured approach to reviewing data sharing and identification practices. They also emphasize the importance of testing data for accuracy post-de-identification to avoid biases that could impact the utility or fairness of the data use. Additionally, the 5 Safes framework provides a comprehensive approach to assessing the risk and appropriateness of data use. Safe projects, ensuring the purpose of data use is ethically and legally sound. Safe people, verifying that those accessing the data have the integrity and skills to handle it responsibly. Safe data, assessing the data for potential disclosure risk. Safe settings, providing a secure environment that limits data access to authorized users. Safe outputs, ensuring that the results of data analysis or research do not inadvertently reveal personal information. Those guidelines and frameworks offer a roadmap for organizations navigating the complex terrain of data privacy and protection, highlighting the need for a balanced approach that respects individual privacy while allowing for the beneficial use of data. So let's start now to talk about instead ransomwares. The discourse on ransomware encapsulates a multifaceted challenge faced by entities across various sectors, ranging from personal households to critical infrastructure. Ransomware, a type of malicious software designed to deny access to a computer system or data until a ransom is paid, often leverages encryption to lock down files or entire systems, spreading through phishing mails or malicious websites. Notably, attackers might not always seek to steal data, but rather incapacitate systems or threaten to leak sensitive information. An emerging trend in ransomware attacks includes triple extortion tactics involving data encryption, threats of data leaks, and denial of service attack to coerce the victims into paying ransoms. This escalation has led to an alarming increase in both frequency of attacks and the sums demanded, with payments reaching millions of dollars in some instances. For example, the Colonial Pipeline incident marked a significant moment, demonstrating the tangible impact of ransomware on essential services and highlighting the complexities of responding to such threats, including decisions around paying ransoms. The rise of ransomware as a service (RAAS) platforms further complicates the landscape, enabling attackers to deploy ransomware without extensive technical knowledge, thereby democratizing the tools needed for cyber extortion. In the realm of cybersecurity insurance, incidents like NotPetya pose intriguing legal questions regarding coverage exclusion for acts of war, with courts deliberating over whether cyber attacks fall under such categories. The evolving jurisprudence around this exclusion reflects the ongoing struggle to adapt traditional legal frameworks to the realities of digital conflicts. Insurance providers such as Lloyd's have begun to refine their policies to make clearly delineate coverage boundaries in the context of state-sponsored actions, underscoring the necessity for legislative and regulatory evolution to manage the growing cyber threat landscape effectively. This overview of ransomware underscored the critical need for comprehensive strategies encompassing prevention, containment, recovery, and the legal response mechanism. Moreover, it highlights the significance of the international collaboration to curb the ransomware epidemic, given the transnational nature of cyber threats and the challenges associated with attribution in the digital domain. Determining the threshold for when downtime due to ransomware attacks necessitates notification is complex and varies by context. The general guidelines suggest using a 72 hours benchmark as a preliminary indicator. Short-term interruptions spanning a few hours might not necessitate broader external actions beyond the immediate containment and recovery efforts. However, extended periods of disruption, such as 5-day halt that affects financial transactions or a 2-day delay in critical services like hospital procedures, likely warrant disclosure to the affected parties for transparency and trust maintenance. The decision to report a ransomware incident isn't straightforward, as instincts may lean towards inaction due to fears of public backlash or regulatory scrutiny. Nonetheless, reporting can have substantial benefits, including assistance from law enforcement in retrieving funds, identifying perpetrators, or even obtaining decryption keys. Furthermore, proactive disclosure can serve public relations interest, showcasing the victim organization commitment to transparency and accountability. The European Data Protection Board, ADPB, emphasizes that ransomware incidents may compromise data availability or confidentiality, necessitating a careful assessment to the attacker's action, data impact, and backup efficacy. Recommendations include employing robust backup strategies, encryption of data at rest, and maintaining comprehensive communication logs, which can reveal additional security concerns. Response strategies to ransomware incidents must always include an internal log, potentially informing data protection authorities, DPAs, and depending on the severity and potential for significant downtime, notifying affected subject directly. In situations where reaching or impacted individuals is impractical or excessively costly, public disclosure becomes necessary. However, the disclosure around ransomware notification does not explicitly cover scenarios involving ransom payments, a critical oversight given the frequency of such a decision in practice. The implication of ransom payment on the obligation to notify, particularly how it affects the assessment and availability loss, and the consequent need to inform consumers pose significant ethical and strategic dilemmas. This gap in guidance raises questions about the potential unintended consequences of notification rules, especially in terms of their impact on organizational decision making regarding ransom payments and the broader objectives of mitigation, information flow, and deterrence. Let's see the strategy against ransomware in the US. The Ransomware Disclosure Act, introduced by Senator Elizabeth Warren and Representative Deborah Ross, aims to mandate companies and organizations, excluding individuals, to report any ransomware payments to the US Department of Homeland Security within 48 hours of the payment. This legislation seeks to provide critical data about ransomware payments, including the amount of ransomware demanded and paid, the type of currency used, and any known information about the entity demanding the ransom. The objective is to enhance the government's understanding of cybercriminal enterprises and the ransomware threat landscape, which has seen a significant increase in attacks and ransomware payments. This act would require victims to disclose detailed information about ransom payments, a move seen as crucial for gathering data to combat cybercrime more effectively. Ransomware attacks have become increasingly prevalent, posing significant threats to national security, critical infrastructure, and the economy, with victims worldwide paying nearly $350 million in ransom in 2020 alone. The urgency for legislative measures to tackle the issue is clear. The proposed bill also includes provisions for the Department of Homeland Security to establish a website for voluntary ransom payment reporting by individuals and to conduct a study on ransomware attacks and the role of cryptocurrency in facilitating these crimes. Let's conclude the part regarding ransomware. The discussion on ransomware payments delves into complex interplay between legality, ethics, and practicality in the face of cyber extortion. It raises the issue of whether paying ransoms in a response to ransomware attacks inadvertently fuels the cybercriminal ecosystem, thereby encouraging more attacks. The US government, through documents issued by the Office of Foreign Asset Control, the OFAC, discourages ransom payments to avoid funding activities that could threaten national security and contravene sanctions law. The OFAC guidelines emphasize the importance of engaging with law enforcement and implementing robust cybersecurity measures as mitigating actions rather than resorting to ransom payments. The conversation extends to the ramification of ransom payments, touching upon the potential for these payments to violate sanctions laws if they end up in the hands of individuals or entities on prohibited lists. The introduction of legislation like the Ransomware Disclosure Act by Senator Elizabeth Warren underscores a move towards a mandatory disclosure of ransom payments, aiming to gather data to combat ransomware more effectively. This legislation, along with the evolving stance of insurance companies on covering ransom payments, indicates a shift towards greater transparency and accountability in dealing with ransomware incidents. The debate around banning ransom payments, especially in the context of state legislation that prohibits taxpayer-funded entities from making such payments, highlights the dilemma faced by victims of ransomware attacks. On one hand, there's the imperative to recover encrypted or stolen data promptly to minimize downtime and operational impact. On the other hand, there's the broader concerns about contribution to a cycle of cybercrime by financially supporting cybercriminals. The legal landscape around ransomware payments is fraught with complexities, including potential tort liabilities for failing to act diligently or making decisions deemed unreasonable. The decision to pay a ransom involves weighing various factors, including the cost of recovery, downtime, the extent of insurance coverage, and the amount of the ransom itself, against the backdrop of an uncertain outcome in terms of data recovery and the risk of recurrent attacks. In conclusion, the discussion on ransomware encapsulates a policy challenge that spans preventive measures, response strategy during an attack, and post-incident recovery and reporting. It underscores the need for a multifaceted approach that prioritizes cybersecurity readiness, legal compliance, and strategic decision-making in face of cyber threats. Let's see the EU approach towards cybersecurity. The Directive EU 2022/2555, known as NIS2, aims to significantly improve the level of cybersecurity within the European Union. This legislation updates and expands upon the Regional Network and Information System (NIS) directive, seeking to address evolving cyber threats and ensure a high common level of cybersecurity across all European states. NIS2 emphasizes the importance of enhancing cybersecurity capabilities within critical sectors and introduces detailed requirements for risk management and incident reporting. It also focuses on strengthening national frameworks, promoting cooperation and information sharing both within the Union and internationally, and setting forth obligations for entities in terms of security measures and incident notification. Key features of NIS2 include: NIS2 identifies sectors of high criticality, such as energy, transport, banking, health, digital infrastructures, and public administration, among others. Entities operating within these sectors are subject to the directive's requirements to ensure their systems are secure against cyber threats. Each EU member state is required to adopt a comprehensive national cybersecurity strategy. This strategy should include a governance framework, policies on supply chain security, vulnerability management, education and training, and measures to raise cybersecurity awareness. Computer Security Incident Response Team SCIRTS. The directive underscores the role of CSIRTs in providing assistance to entities, including monitoring and analysis of cyber threats, issuing early warnings and responding to incidents. NIS2 mandates for establishment of national frameworks and designates authorities responsible for cybersecurity, promotes cooperation and information sharing through the creation of networks and groups to facilitate a collective response to cyber threats. The directive encourages EU member states to collaborate with third countries and international organizations aiming to strengthen global cybersecurity efforts. This includes sharing information about cyber risk and incidents and supporting each other in responding to cyber threats. Entities affected by the directive must adopt appropriate technical and organizational measures to manage cybersecurity risk and report significant incident to relevant authorities, or CCIRTs. NIS2 represents a significant step forward in the EU's efforts to safeguard its digital environment against cyber threats. By establishing a more robust regulatory framework, the directive aims to enhance the security of networks and information systems across critical sectors, improve incident responsibility capabilities, and foster a culture of cooperation and information sharing both within the EU and globally. This comprehensive approach is crucial for addressing the complex and evolving landscape of cyber threats, ensuring the resilience of the EU's digital infrastructure and protecting the interests of its citizens and businesses. So let's continue talking of the EU approach to cybersecurity, which is comprehensive, aiming to enhance resilience, promote technological sovereignty, and maintain leadership in the global digital landscape. It is built on the strategic objectives that include the operational capacity to prevent, deter, and respond to cyber threats, and fostering cooperation to support a secure, global, and open cyberspace. Here's an overview of the key legislative and regulatory measures that shape this approach. The EU cybersecurity strategy. The strategy underscores the EU's commitment to bolstering cybersecurity across the Union. It involves strengthening the EU Agency for Cybersecurity, ENISA, to shape policies, advise national authorities, and coordinate actions to ensure the security of digital products, services, and processes. The strategy introduces the European Cybersecurity Certification Framework, facilitating EU-wide certification to enhance the security of the digital ecosystem. There is then the Cybersecurity Act, which is Regulation EU 2019/881, in which the Act significantly empowers ENISA and establishes a certification framework aimed at securing digital products, services, and processes across the EU. It serves as a cornerstone for the EU's cybersecurity policies and initiatives. NIS2 Directive, Directive 2022-2555, as a successor to the original Network and Information System NIS Directive, NIS2 expands the scope to include both essential and important entities across critical sectors like transport, energy, banking, and digital services. It mandates strict incident reporting requirements and introduces several penalties for non-compliance, aiming for enhanced cybersecurity resilience and information sharing across the EU. The directive sets a timeline for transposition by member states by October 2024. Cyber Resilience Act (CRA). The CRA aims to establish horizontal cybersecurity requirements for hardware and software products, enhancing the security of products throughout the EU. It is expected to be fully enforced between 2026 and 2027, reflecting the EU's proactive stance on product cybersecurity. Cyber Solidarity Act instead was proposed in April 2023, and this regulation aims to fortify the EU's capabilities to detect, prepare for, and respond to significant cybersecurity threats. It introduces mechanisms like the European Cyber Shield for enhanced detection and situational awareness, a cybersecurity emergency mechanism for incident response, and a review mechanism for assessing significant incidents. ENISA plays a pivotal role in coordinating this effort. In addition to these specific measures, the EU cybersecurity framework is supported by other regulations like the GDPR for personal data protection, the AI Act for ensuring cybersecurity measures in IT systems, and sector-specific regulations such as DORA for the banking sector and various measures for telecommunication, energy, and other critical infrastructures. The holistic approach underscores the EU commitment to establishing a secure, resilient, and trustworthy digital environment, both within its border and in its interaction on the global stage. So we have seen the regulation in general, we've seen a bunch of them. Now let's see one specific So we have seen the regulation in general, we've seen a bunch of them. Now let's see one specifically created for the cybersecurity spectrum in Europe. And that's the NIS2 directive, which introduced a comprehensive risk management and reporting obligation for entities operating within the EU, significantly expanding upon its predecessor framework to strengthen cybersecurity across critical sectors. Here's an overview of key aspects based on the provided details. Articles 20 and 21 of NIS2 are related to governance and risk management measures. Governance is essential in Article 20, and important entities must have their cybersecurity risk management measures approved by the governing bodies. Member states are tasked with ensuring that governing body members and staff undergo training to understand and evaluate cybersecurity risk effectively. Then, in Article 21, the cybersecurity risk management measures, entities are required to adopt a blend of technical, operational, and organizational measures to manage cybersecurity risk. These measures must ensure an adequate level of security proportional to the risk, incorporating current knowledge, standards, and costs consideration. Entities must implement a null-hazard approach for thorough protection, covering policies for risk analysis and information system security, effective incident management, supply chain security and secure development, procurement and maintenance of system, cyber hygiene practices and cybersecurity training. Should no compliance with these measures be identified, entities must undertake necessary corrective action promptly. Union level coordinated security risk assessment is then decided in Article 22, in which the directive introduces frameworks for union-wide security risk assessment of critical ICT supply chains, aiming to identify vulnerabilities and enhance security resilience. On Article 23 of NIS2 is then underlined the reporting obligation, for which entities are obligated to report significant incident to their national CSIRTs or competent authorities promptly. This includes a structured notification process ranging from initial warning to final reports, facilitating an effective response to cyber threats. On Article 24, from 24 to 27, there is then defined the certification, standardization, and the jurisdiction. Certification and standardization, which is decided in Article 24, the directive promotes the use of European cybersecurity certification to schemes and standards to harmonize cybersecurity measures across the EU. Entities are generally subject to the jurisdiction of the member states where they are established. The directive also details the process for determining jurisdiction and requires entity to submit specific information for registry purposes. There is then, on Article 28, the aim to enhance the DNS security framework. TLD name registries and domain name registration services providers are required to maintain accurate, complete domain name registration data, enhancing the security and the resilience of the domain name system, DNS. These two directives approach underscores a significant shift towards a more robust, coordinated, and standardized cybersecurity framework across the EU, emphasizing the importance of governance, risk management, and transparency in combating cyber threats. This legislative evolution reflects the EU commitment to safeguarding its digital ecosystem and the critical services that depend on it. On Article 29 of the NIS2 directive is emphasized the importance of cybersecurity information sharing within the European Union. It outlines a strategic approach for enhancing collaboration among a broad range of entities to strengthen collective cybersecurity defenses. The key points under this article include the voluntary information exchange. Entities covered by the directive as well as relevant outside entities are encouraged to voluntarily share crucial cybersecurity information. This encompasses details about cyber threats, vulnerabilities, and adversary tactics, aimed at bolstering efforts to prevent, detect, respond to, and mitigate cyber incidents. The directive highlights the significance of sharing intelligence on cybersecurity matters to raise awareness, support defensive measures, and facilitate vulnerability remediation, and promote collaborative research between the public and private sectors. Acknowledging shared intelligence as a cornerstone, the directive aims to combat cyber threats more effectively and boost the cybersecurity ecosystem's resilience. Article 29 specifies that information exchange should occur within communities comprising essential and important entities, their suppliers and service providers. It details the operational framework for these arrangements, including the use of ICT platforms and conditions for sharing sensitive information. Member states are tasked with facilitating the creation of information sharing arrangements and may set guidelines for public authorities' involvement and conditions for sharing information. Entities engaged in this arrangement must notify competent authorities about their participation. The European Union Agency for Cybersecurity, ENISA, is identified as playing a supportive role by disseminating best practices and offering guidance, underscoring a collaborative effort to enhance cybersecurity across the EU. Through Article 29, the NIS2 directive seeks to establish a more secure and resilient digital environment across the European Union by leveraging collective knowledge and resources for a unified defense against cyber threats. So, continuing on the same topic as Article 29, we have on Article 30 the NIS2 directive, a framework for the voluntary notification of cybersecurity incidents within the EU, aiming to foster a more proactive exchange of cybersecurity-related information between entities and national cybersecurity incident response team, CSIRTs, or competent authorities. This provision is designed to complement the mandatory notification obligation detailed in Article 23, broadening the spectrum of cybersecurity incident reporting beyond what is strictly required by law. The primary goal of Article 30 is to encourage entities, including those not directly covered by the directive, to share information on cyber threats, significant incidents, and even near misses on a voluntary basis. By facilitating such a comprehensive flow of information, the directive aims to enhance the overall cybersecurity awareness, preparedness, and resilience across various sectors within the EU. This proactive approach to information sharing recognizes the vital importance of early threat detection and swift incident response in mitigating cyber risk. By pooling knowledge about potential cybersecurity threats and vulnerabilities, entities can better protect themselves and others within the EU against the evolving cyber threat landscape, thereby strengthening the collective cybersecurity posture of the Union. Article 31 introduces now the next argument that we have about NIS2 directive, that is the supervision and enforcement. Article 31 focuses on the general aspect concerning supervision and enforcement and sets the stage for how member states are expected to monitor and enforce adherence to the NIS2 directive. It underlines the importance of competent authorities in conducting effective oversight and implementing necessary action to ensure compliance. The article suggests a risk-based approach to prioritization of supervisory tasks, which is crucial for dealing with the most significant threats first. Furthermore, Article 31 promotes collaboration among different supervisory bodies, especially in instances involving breaches of personal data. This coordination ensures that entities, particularly those in the public administration sector, are regulated with operational independence, avoiding conflict of interest and ensuring unbiased enforcement. The principles laid out in Article 31 are critical for a unified and efficient application of the directive across the EU. They provide a systematic method for supervision and enforcement aiming to maintain a high level of cybersecurity across member states. Article 32 and 33 then build on this foundation by specifying the supervisory and enforcement action applicable to both essential and important entities. These articles list the powers of competent authorities, detailing their ability to conduct inspections, audits, and impose enforcement measures such as warnings, binding instructions, and administrative fines. The intention behind these provisions is to directly compel entities to comply with the cybersecurity standards established in the directive, ensuring a secure digital environment throughout the EU. The NIS2 Directive Articles 34 and 37, Articles 34 through 37 form a comprehensive framework for supervising and enforcing cybersecurity measures across essential and important entities within the EU, as a breakdown of their implication. The Article 34 details the general condition for imposing administrative fines. The article emphasizes the need for administrative fines to be effective, proportional, and dissuasive. It allows for significant financial penalties, which can be either a fixed sum or a percentage of an entity's global annual turnover, depending on the severity of the non-compliance. The approach is designed to ensure that entities take their cybersecurity obligation seriously and comply with the directive requirements. Article 35 describes the breaches entailing a personal data breach. Article 35 addresses a situation where a cybersecurity breach also involves a violation of personal data protection law, specifically the GDPR. It outlines the process for cooperation and communication between the NIST competent authorities and GDPR supervisory authorities. This coordination aims to handle data breaches effectively without imposing redundant sanctions for the same incident. Article 36 describes the penalties. This article mandates member states to establish penalty rules for breaches of the directive, ensuring they are effectively deterrent. It requires these rules, along with any updates, to be communicated to the European Commission, promoting transparency and consistency in the enforcement of cybersecurity measures across the EU. On Article 37, mutual assistance is the mutual assistance article, which aims to facilitate cooperation and mutual assistance among member states. It is particularly relevant for entities operating or having systems across different jurisdictions. The article set out procedures for information exchange and joint supervisory activities, ensuring the directive consistent application and effectiveness throughout the EU. These articles collectively enhance the EU's regulatory framework for cybersecurity, ensuring a robust approach to supervision, enforcement, and cross-border cooperation. They underline the importance of a high level of network and information security across the European Union, crucial for protecting the digital infrastructure against emerging cyber threats. The Regulation EU 2022-2554, effective from January 17, 2025, targets enhancing digital operation resilience in the financial sector, a response to the critical reliance on information communication technology (ICT) within financial services. It addresses systemic vulnerabilities due to the interconnectedness and interdependencies of ICT systems across approximately 22,000 union financial entities, acknowledging the potential for localized cyber incidents to rapidly escalate across the financial system. This regulation aims to harmonize legislative disparities and regulatory approaches concerning ICT risks, thereby facilitating the smooth functioning of the internal market in financial services and ensuring competitive equality among financial entities operating in different member states. The disparities, particularly in digital operational resilience testing and monitoring of ICT third-party risk, pose obstacles to the internal market's functioning and could, if unaddressed, detrimentally impact market participants and financial stability. To attain a high common level of digital operational resilience, the regulation sets uniform requirements regarding the security of network and information system crucial to the business processes of financial entities. Key elements include ICT risk management, reporting of major ICT-related incidents, digital operational resilience testing, information and intelligence sharing on cyber threats and vulnerabilities, and measures for managing ICT third-party risk. Digital operational resilience encompasses the capacity of a financial entity to maintain operational integrity and reliability by securing the networks and information systems supporting its financial services, including during disruption. The regulation emphasizes proportionality, governance, identification of roles and responsibility, and establishment of comprehensive digital operational resilience testing programs for assessing preparedness and identifying weaknesses in digital operation. Furthermore, the regulation mandates financial entities to report major ICT-related incidents and voluntarily notify significant cyber threats to competent authorities. It also introduces a strategy for managing ICT third-party risk, considering the financial ecosystem intrinsic codependency on certain ICT services critical to the stability and integrity of the Union financial system. In summary, Regulation EU 2022-2554 aims to ensure that the financial sector's operational practices are resilient to ICT risk, fostering stability and integrity within the Union financial system throughout harmonized comprehensive measures for digital operational resilience. So this is the end of the cybersecurity section for preparation for the exams, and I'm going to prepare by next week, I hope so, the 50, 100 questions that could happen to pop out in the exam basically, and provide an answer for all of them so that I could even refresh my knowledge and so on. So bye.